record, take photographs, blog or tweet at this meeting. I would ask at this point if anyone is intended to film the meeting. I would ask anyone who is recording to avoid any disruption of the meeting and to avoid filming members of the public. If you do film members of the public, there is potential for civil action against you by anyone who has not given their permission to be filmed. We are not expecting a fire drill. That took place this morning at approximately 10 o'clock. In the event of a fire alarm sounding, please leave the building as quickly as possible. The Government Service Officer will direct you to the appropriate exit and assembly point. Agenda item 1, apologies for absence. I don't think there's anyone absent. Agenda item 2, members to declare any interest in matters to be discussed at the meeting today. No. To confirm the meetings of the meeting which was held on the 8th, 9th and 10th of January 2018 as a correct record. Agreed? Thank you. Agenda item 4, that takes us into consideration of sanctions in relation to MC/06/0616 following a finding from the Subcommittee of breaches of the Members' Code of Conduct at the Substantive hearing on the 8th, 9th and 10th of January 2018. Sorry? Yeah. You're going to read it here.
Chair, before we move on to consider the substantive part of the hearing, there is an application from Councillor Hussein's solicitors. I don't know, has the investigating officer, have you received a copy of this?
Yes, I have just received a copy.
Perhaps if I read it out so that it's on record what the application, the basis of the application. This is addressed to the monitoring officer. We write further to the above-mentioned matter and previous correspondence in this matter due to the delay in supplying Councillor Hussain with a decision notice and the failure to provide Councillor Hussain with the minutes of the hearing on the 8th, 9th and 10th of January 2018. Our client requests that the sanctions hearing listed for the 23rd of March 2018 at 1 p.m. today be adjourned. As detailed previously, the delay in providing the decision notice, the failure to provide the minutes and the personal circumstances of the solicitor with conduct of Councillor Hussein's case has prevented Councillor Hussain from being in a position to consider whether to issue a legal challenge to the decision of the hearing on the 8th, 9th and 10th of January 2018. Accordingly, our client avers that it is not in the interest of justice for the sanction hearing to take place, and our client places you on notice that they reserve the right to challenge the decision in due course. We look forward to hearing from you in this matter. That is in an email at 12:05 this afternoon, so just over an hour ago. Chair, what I suggest is that if Ms Price, the investigating officer, has any comments or submissions to make on the application, she makes those. I will then provide some brief advice in relation to the application to adjourn. Then if Mr Tomkinson, the independent person, has any comments on the adjournment application, he makes them, and then I'd suggest you then retire briefly to consider the application.
Okay. Now over to you, Marie. It's your request if you want to take comments, please.
Thank you. Just a couple of very short points to make, Chair. So firstly, I'm disappointed that this application has come in just 55 minutes before the hearing is due to start. And I've noted that there's really very little detail of the actual grounds for the application itself. What I would say on the very sparse details we have got, firstly, delayed decision notice. Well, what to say to that point is Councillor Hussain and his representative were aware of the decision on the 10th of January 2018 when it was announced and webcast out to the public. So I'd say he's not really placed at any disadvantage to that respect from a delayed decision notice, because it's been in his knowledge for quite some time. The same point really flows to the minutes of the meeting. Quite clearly, again, the full hearing, the 8th, 9th and 10th, were webcast out to the public, so again he was open to view that and see exactly what was said during the meeting and respond accordingly. I actually provided my written representations to Councillor Hussain and his representative on the 19th of March, so he's aware as well of what I'm going to say to you today and what I've already supplied to you. I would say there's been ample opportunity to provide written representations by Councillor Hussain and his representative, and I submit that really it just isn't in the public interest to delay this sanctions hearing any further. And that's all I have to say, Chair.
Thank you for those comments.
Thank you, Chair. I obviously advised at the previous hearing in some detail in relation to adjournment, so I will take my advice fairly briefly. In considering an adjournment, you have a wide discretion. You will need to exercise that discretion so as to achieve the fairest outcome. In balancing, you will need to engage in a balancing exercise. On the one hand, you have the reasons that Councillor Hussain has advanced for adjourning the hearing. On the other hand, there is clearly a public interest in the standards complaint being finally and completely determined without any further delay. That is both an interest that the Council has and also a wider public interest. In considering the reasons that have been advanced by Councillor Hussain, he has essentially three reasons advanced. One is in relation to the delay in providing the decision notice. You will need to take account of that delay, but also you will need to take account of the fact that the hearing was broadcast at the time on the web. It's been available, the full record of the hearing has been available since early January on the web, and Councillor Hussain has indeed been aware of the outcome of that hearing, both as to the adjournment application and the substantive decision on breach of the code since respectively the 8th and 10th of January. He has had the decision notice for over a week. That is another factor you will have to consider. And indeed the application put today appears not to be on the basis that he is unable to prepare for this hearing, but rather that he wants to consider his position in relation to a legal challenge to the decision reached at the hearing on the 8th to 10th of January. There's also concern about the minutes being not being provided. Again, minutes necessarily only summarise what has happened at the hearing, and that hearing, the full contents of that hearing has been available on the internet for some time. The third point that's raised is in relation to his solicitor not being available because of personal circumstances, which you'll have seen what those are in previous email. However, Waitman's, Councillor Hussain's solicitors are a large firm. They specialise, among other matters, in local government, and you might want to bear in mind whether it would have been reasonable for him to find another solicitor within the firm who could have covered, and indeed he has not himself attended today. It's also to be borne in mind is that this is of course not a hearing to deal with whether there's been a breach. That was being dealt with already. It is only addressing the question of what, if any, sanctions should be imposed on Councillor Hussain. So you will need to bear all those matters in mind. You will need to decide what, in your view, is the fairest approach, whether to grant the adjournment or to refuse the adjournment. I don't know if Ms Price has got any comments on my submissions, or any members of this subcommittee have got any questions.
Any questions at all from the Councillor?
Thank you, Chair. I think I understand that. I understand the position that the decision that's referred to in the adjournment request, where the solicitor says that Councillor Hussain will reserve the right to challenge the decision in due course. It's not the decision in relation to the if any sanctions hearing were to proceed. It's the decisions that were taken on the 8th, 9th and 10th. And that if the sanctions hearing were to proceed, that would not compromise that right to challenge the decision from January. Is that the case?
Yes, that's precisely the case. They're two entirely separate matters. He could, if entirely a matter for him, obviously, and his advisors, but it would be a matter for him if he wants to make any challenge to the decision made in January. In my view, it's entirely separate matter from whether or not this hearing should proceed. Councillor Troy, you like you, I have the email in front of me, and it appears to be focused on his ability to challenge the previous decision rather than specifically directed to being able to participate in this hearing.
Can I just confirm probably what Councillor Trow is saying? We need to know that the outcomes of today, the reason why we're here, are not going to be influenced by what Councillor Hussain is asking for now. Is that what we're saying? Do you know what I'm asking? We're here, as you say, for the sanctions.
Sorry, just to be clear about my question, it wasn't. My question was that the final sentence of the submission for the adjournment says, accordingly, our client avers that it is not in the interests of justice for a sanctions hearing to take place. And our client places you on notice that they reserve the right to challenge the decision in due course. And so I was just wanting to be clear that where there is a right to challenge a decision, the decision will be the decision the decision that was made at the 3-day hearing in January of this subcommittee. That is the decision that is being referred to here. And that if we were to proceed with the standards hearing today, with the sanctions hearing today, that would not in any way compromise Councillor Hussain's right to challenge the decision made in January.
No, that is correct. I mean, as you say, Councillor Troy, that the ultimate request is to adjourn the sanctions hearing because it's said not to be in the interest of justice. But one of the bases on which it is said, appears to be said, that the hearing should be adjourned is that he hasn't had the opportunity to consider whether to challenge the previous hearing. And my advice is that that is essentially a separate issue. Whether or not Councillor Hussain has any grounds to challenge that decision and whether he wishes to do so is entirely separate, is not affected either by your decision to proceed with this hearing or not to proceed with this hearing today. If he has a challenge, he can bring it either way. So my advice was simply that it seems to me to be a logical disconnect between that reason and why one should adjourn the hearing. Obviously, if he were to challenge the previous decision and successfully challenge it, then the finding of breach may be quashed and necessarily any sanctions that is imposed today would also fall away and may need to be reconsidered. But that's a different issue.
Thank you. Maria, as the investigating officer, do you want to come back to make any comments, please?
I have nothing further to add, thank you.
Thank you. And now I'll take the opportunity of ringing Tompkinson, our independent member to the subcommittee, to make any comments. Over to you, please, Mr. Tompkinson.
Thank you, Chair. I won't elaborate on the points that have been made by the investigating officer and also by Mr. Cornwall in terms of the length of time it has taken to get to this point of a sanctions hearing, or other details relating to the fact that in the public domain was clearly for some significant time the webcast and other material. And I'm very conscious that Councillor Hussain is quoted in the local press as commenting on the results of the standards hearing back in January. Of course, I continue to be sorry that Councillor Hussain is suffering some incapacity which prevents him dealing with this matter in perhaps the expeditious way he wished to, and obviously concerned about his legal representative's personal situation. I am, however, very persuaded by the fact that in the correspondence from the solicitor, he appears to continue the theme of not wishing to engage with the standards process in any way, shape or form. And that is, in my mind, of considerable concern and would be considerable concern to the public. It seems that Councillor Hussain or his representative or both together have decided that the standards process is of no interest or value to them, and therefore they are prepared to potentially incur the Council in considerable further cost if there were to indeed to be a further action. And I think that that suggests to me that Councillor Hussain does not have the interests of good governance of Sandwell Metropolitan District Council at his heart. That being the case, he obviously does have an opportunity to defend himself and to take whatever course of action he thinks is appropriate. Turning to the other side of the public interest argument, a further adjournment of this matter, I believe, would not be in the interests of the public of Sandwell because of the length of time that it has gone on. And clearly the fact that a decision has been in the public domain now for 10 weeks, and members of the public will considerably wonder why the Council has not been able to bring this matter to a conclusion by concluding the sanctions that may or may not be appropriate in this case. I would therefore consider that adjournment is not appropriate. Thank you, Chairman.
And thank you, Mr. Tompkinson. I'll now take us through the subcommittee that we adjourn to discuss whether we agree to the adjournment or we do not agree to the adjournment. Thank you.
This is a brief summary of the subcommittee's reasons for its decision to refuse the application. This is a decision of the 4 members of the subcommittee with the advice and assistance from myself and from the independent person. 1. The subcommittee was concerned that Councillor Hussain's solicitor's email applying to adjourn the hearing was only sent at 12:05 today, 55 minutes before the hearing. 2. The subcommittee carefully considered the application in the email of 23rd of March 2018 and in a previous exchange between the monitoring officer and Councillor Hussain's solicitors on 16th of March 2018. 3. Councillor Hussain has been aware of the decision not to adjourn the 8th to 10th of January 2018 hearing since the 8th of January and has had the summary reasons since then. He has also been aware of the substantive decision on failure to comply with the code since the 10th of January 2018. The subcommittee also noted that the recording of the full hearing on 8th to 10th of January 2018 had been available on the internet since shortly after that hearing. Councillor Hussain was then provided with the full decision notice on the 15th of March 2018, over a week before this sanctions hearing. 4. The subcommittee also noted that the hearing was simply to consider sanction. The history of the case and the breach of the code had already been considered and determined. 5. The subcommittee noted with sympathy Councillor Hussain's solicitor's recent bereavement. However, the subcommittee noted that he had been on leave since late February, and the clearest statement as to how long his leave would be likely to continue was that it would be, quotes, the next couple of weeks, as from the 16th of March 2018. However, the subcommittee noted that Waitmans was a large law firm with considerable expertise in local government, and it would expect it to be able to arrange cover if a solicitor was on leave for a number of weeks. 6. The investigating officer had provided Councillor Hussain with her written representations on sanction on the 19th of March 2018. 7. The subcommittee noted that the 23rd of March 2018 email from Councillor Hussain's solicitor appeared to advance the case for adjournment not on the basis that he could not prepare for this hearing, but on the basis that he had not been able to consider a challenge to the previous decisions in January. However, the subcommittee did not consider that any decision that Councillor Hussain, any desire that Councillor Hussain might have to challenge the previous decisions was a reason not to proceed with this hearing. 8. The subcommittee considered that there was a very strong public interest in the standards process being fully resolved. The subcommittee considered that Councillor Hussain had had a reasonable opportunity to prepare for the sanctions hearing. 10. Balancing the reasons advanced by Councillor Hussain against the public interest in concluding the matter, the subcommittee unanimously concluded that the fairest approach was to proceed with the hearing and refuse the adjournment application. So that's the subcommittee's reasons for refusing adjournment. Perhaps while I'm speaking it would be helpful if I briefly outlined what the procedure now is. The normal procedure would be for the subject member to make any observations that they had in relation to what action, if any, should be taken following the finding of failure to comply. However, Councillor Hussain and his representatives have not attended, nor have they provided any written representations to the subcommittee, despite such representations being invited by the monitoring officer to be supplied by 10 a.m. this morning. So in those circumstances, the next step would be for the investigating officer to make any representations that she has on sanction, and then if the committee has any questions for her, they can ask those questions, as they would have been able to ask Councillor Hussain and his representative had they attended. Then the independent person will give his views on sanction, and then finally I will provide my legal advice in relation to sanction, at which point the subcommittee will have an opportunity to ask me any questions on my advice, and then the subcommittee will need to then adjourn to deliberate in relation to sanction before coming back and announcing its decision. So I think, Chair, that the next thing that needs to happen is for Ms Price to make any submissions that she has.
Okay. Maria.
So I have submitted written representations to you, which are at page 88 of the small bundle. I'm happy to take you through those if you want me to. I've got nothing further to add to those. So I'll be at your discretion, Chair, on whether you want to talk you through them.
Is there any questions from the panel?
Yes, I just want to ask about there's a point here. I'm struggling to find the actual paragraph. Is there one where the recommendation is the proposition that Councillor Hussain should have make any direct contact with officers below the level of director? It suggests. Is this practicable? Is this something that could actually achieve? I mean, my understanding is that. The Councillor is saying still has responsibilities as a local ward councillor and to report casework in and so forth. Are we suggesting, are we making it impossible for him to actually fulfil that responsibility?
I'd argue not. So I think we're dealing with paragraph 9 and 10 of my submissions. And what I'm actually saying there is not to do it without contacting through the director first. So it's not that there's no contact with officers, it's just that the appointment or the arrangement should come through the relevant director first, which should still be a manageable situation. It's really dealing with that finding that we've made about officers being put in a position where they're compromised. So this is just to effectively mitigate that.
Councillor O'Connor.
Yeah, a second question, just so I'm clear about this. Paragraph 11 refers to the content of what you propose should be a training requirement, a training course. And several of the other recommendations you're making suggest that if, as and until that training course is completed, is it? All I want to be clear on is that who determines the actual content of this training course? Who has to be satisfied that it has been completed, and that the necessary lessons have been learned? If that's what you're suggesting, but because there's no indication in this that you're looking to do. I mean, that may be what you're suggesting. Simply that there should be a training course that includes these items, and that if Councillor Hussain wishes to arrange that, then. Or attend those meetings, then that's satisfactory. Is that what you're suggesting?
Not quite. So the proposal is that it's actually the monitoring officer who arranges the relevant training for Councillor Hussain. Where I am saying that should be at Councillor Hussain's own expense, but then it would be for the monitoring officer to ensure that the relevant training is in fact completed. Once that's completed, then the other sanctions almost fall away. But yeah, it would be effectively managed by the monitoring officer.
Any other questions from the panel? Tomkinson.
Thank you, Chairman. I wonder if I could take you first to paragraph 8 and 9 of your submission. If I turn to page 94 of the Council Code of Conduct. Forgive me a second, I'll find the reference in a moment. Yeah, page 98. Sorry, my apologies. The sanctions that are outlined there, 9.1 and 9.2. 9.1 says recommend to the members group leader regarding removal from committee or subcommittee, and also recommend to the leader of the council member being removed from the cabinet. And then 9.4 recommend to council to remove from all outside appointments. Your paragraphs 8 and 9 don't actually say that. It suggests that the sanction is not be permitted. Am I correct that in fact what you actually mean is that it should be a recommendation as appropriate?
Certainly as appropriate. And the reason that we've got there is not applicable is because, as far as I know, is not on any of these panels at the moment. So yeah, you're quite right.
Yeah, okay, fine. Thank you for that. I wonder if I could take you to the training. I'm grateful that on the top of page 90, under paragraph 11, you set down some reference to some of the content of the training. I'm aware that there were some other issues that were raised during the hearing on the 8th, 10th, 9th January regarding Councillor Hussein's behaviour. And I wonder if I could get a comment from you as to whether or not you think a number of things are appropriate. So firstly, role as a member.
Sorry, maybe just clarify what you mean as...
Sorry, my apologies. Do you think that in addition to the things you've outlined in paragraph 11, there should also be a content about the role of a member?
So, yes, that would be appropriate.
Do you think also that would be appropriate role as a cabinet and portfolio holder?
Yes, at the time, obviously, Councillor Hussain was a cabinet portfolio member. He isn't at the moment, but yes, certainly that would be appropriate.
Relationships with officers?
Yes, certainly.
Right. Proper conduct of property transactions?
Yes.
Achieving best value or best consideration?
Yes.
Thank you. I wonder if I could also return to the comment from Councillor Trow about your suggestions in respect of a sanction regarding contact with officers. Like Councillor Trow, I have some difficulty in understanding how this could possibly be policed. Given the means of communication that we have available to us all, and particularly Councillor Hussain as a member. Whilst I recognise that what you've suggested is that contact should only be with a director or in his authority a subordinate officer, have you any views as to the manner in which that communication should take place?
The way I would play it is through a director, so contact needs to be made with an officer. Like you said, we've got lots of communication methods available now, which make it pretty easy to contact a director and say, I need to contact Officer X, and then the director can arrange that relevant contact. So I'm not saying no, never. I'm just saying through a recognised means or a step means of doing so.
Okay. I could understand how some members of the public in the constituency represented by Councillor Hussain would find that an extremely alarming and restrictive sanction. Would you be prepared to consider that the sanction should be mitigated to the extent of allowing Councillor Hussain to raise matters directly as appropriate in cases of urgency or particular need?
Yes.
No further questions. Thank you, Chairman.
Just for clarification, it's number 5 on page 89 about the profile, that what would be submitted under that. Would that happen after we agree sanctions today? Would it be immediate?
Yes. Obviously dependent on the loading, but yes.
May I come back, please, Chairman? Yeah. This question is not very well phrased or well formed in my mind, so I do apologise for that. In paragraph 5, the paragraph that Councillor Shackleton has just referred to, the implication is an either-or situation, either when the training is completed or, as you described it, the last day of voting in the next round. I'm very conscious that the next round of voting is some 6 weeks away. And I guess it's not possible for the training, although it could be, not possible necessarily for the training. So would you, in that respect, if, say, and I'm hypothesising here to the nth degree, if indeed the training was completed by, say, June of 2018, and Councillor Hussain next stood for election in 4 years' time after May 2018, you would be more than prepared to see, or your recommendation is, that the sanction that is imposed under that heading would end when the training is completed and not carried on for another 3.5 years.
That's correct, yes.
There's just one point I want to make. It's on the same page 9, and it's paragraph 10. Just explain this to me, please. Further, we submit that the committee should direct that pending the suggested training, Councillor Hussain must not have any direct contact with officers below the level of director. Could you explain that to me, please?
So this is a point we've just been making about how practical that would be, and I've said, yeah, in emergency situations, fine, I'm perfectly content with that. But what I'm basically saying here is once the relevant training has taken place, then that sanction would fall away.
Yeah, because apparently that relevant training wouldn't take place in Sandwell, would it? It would be done with another authority. Is that correct?
That would be something that the monitoring officer would arrange, yeah.
Other questions at all from the panel? Councillor?
Sorry, Chairman, I'm still struggling with this issue here that you just raised as well. And I'm trying to think it through in my own mind. So, just to be clear, what I think you're saying is the recommendation is that in order to prevent the unfortunate circumstances of contact directly with officers in the way that happened previously, Councillor Hussain would not have the ability to contact any other officer other than a director or with a director's position until the training was completed. And at that point he would be free to go back to exactly the situation he would be in as presumably any member of the council.
Yes.
Okay. Would you have thought about this and have decided not to go in, but I would ask you the question. If the subcommittee decided that they needed to impose the most severe sanction that was possible, would it be, in your view, appropriate for that sanction to be changed so that during his term of office, for sake of argument, he had no contact other than through a director?
Yes, it may well be appropriate for the panel to determine that. So yes.
No problem whatsoever. Mr. Dickinson, back to you now to give advice to the panel, please.
Apologies, Mr. Chairman. I'm going to paraphrase what would be the substance of my full advice to the panel, and I hope that members will indulge me in that. I've looked at this in two ways. Firstly, in terms of aggravating factors, and secondly, in terms of mitigating factors. As it turns out, the aggravating factors tend to be the same for both the sale of toilets and for the cancellation or reduction of parking tickets. So firstly, and please if you take it in terms of both of the areas of breach, the events that led to the breach were, in my view, part of a pattern of inappropriate behaviour on behalf of Councillor Hussain. Councillor Hussain was governed by the Statutory Code at the time of the sale of toilets and the Council's Voluntary Code at the time of the cancellation or reduction of parking tickets, and will have acknowledged his need to adhere to the code when he was accepting office as a councillor. Councillor Hussain at the time held a cabinet post and was deputy leader at the time of the events and that led to the breach, and was in receipt of a special responsibility payment. And in my view that imposes a higher standard of conduct on Councillor Hussain than, quote, an ordinary member of the council. Councillor Hussain has apparently displayed no understanding that a breach may have occurred, and indeed in the submission from his solicitor today seeking an adjournment, he seeks further to challenge the decision that the subcommittee has made previously in January, and has no indication that he understands the reasons why that decision was made. Councillor Hussain has failed to arrange, and I accept that there is an issue about his continuing illness, for any meaningful action on his behalf to engage with the standards hearing process, in frustration of his obligation to do so. Councillor Hussain has displayed a lack of consistency in his explanations for the events that were complained about. Councillor Hussain has directly caused costs to this council, and by implication the public purse, by his challenge to the process through his legal action to prevent legitimate inquiries into the complaint taking place. Finally, Councillor Hussain's actions have led directly to a financial loss to the council. Those are, in my view, the aggravating factors. In terms of the mitigated circumstances, they again break down into the sale of toilets and to the cancellation reduction of parking tickets, and there are some slight differences here. In the case of the sale of toilets, these events took place nearly 7 years ago, and it is possible the set of circumstances would not reoccur. Councillor Hussain did cooperate, at least in part, with the investigating officer and other inquiries about the events, and obviously the RAG report did involve him being a witness. Councillor Hussain's illness has prevented him fully engaging in the latter stages of the hearing process, and again may well have prevented him providing a full and robust comment at today's meeting. Controversially, I accept, it is not absolutely clear to me what gain, financial or otherwise, Councillor Hussain personally made from the sale of the toilets, although I will accept the evidence is extremely unclear, and in actual fact the evidence of achieving a personal gain was not complained about and was not the subject of the investigating officer's report. I note, however, as well that Councillor Hussain in one interview offered to recompense the council if I have done anything wrong. I'm more than happy to pay back. I do not want people I represent to lose money. In my view, that indicates that Councillor Hussain does have some recognition that there may well have been, by his actions, some loss to the council. In respect of the parking tickets, I note that Councillor Hussain, almost without exception, cooperated with the investigation and did admit to the investigating officer that he did speak to officers about the parking tickets that were subject of the investigation. So overall, how severe is the breach in my opinion? In respect of the sale of toilets, I consider that the breach is at the most severe end of the spectrum, and accordingly the sanction should reflect that. In respect of the cancellation reduction of parking tickets, I consider that the breach is at the severe end of the spectrum, and accordingly the sanction should reflect that. Thank you, Mr. Chair.
Back with you, please, James, legal advisor.
Thank you, Chair. I'll provide my legal advice in relation to sanction. At the end of it, I will obviously take any questions from the subcommittee, and will also ask Ms Price if she has any observations on my advice, as indeed I would have done with Councillor Hussain and his solicitor had they attended. I've already briefly outlined, I dealt with my advice on procedure earlier, so I now turn to substantive advice on deliberation. Some of the advice I provided previously at the hearing on the 10th of January 2018 in relation to how the subcommittee should go about its deliberations remains relevant to the decision that the subcommittee will take today on sanction. I'll briefly repeat that advice insofar as it's relevant, and I start by making some general points. First, looking at the statutory background, the Council has a duty to promote and maintain high standards of conduct by members and co-opted members. See Section 27(1) of the Localism Act 2011. In pursuit of that objective, the Council must adopt a code of conduct dealing with the conduct expected of members when they are acting in that capacity, i.e. in their capacity as authority members. See Section 27(2) of the 2011 Act. Then the Council must have in place arrangements to do two things: A, to investigate allegations in relation to breach of the code, and B, under which decisions on those allegations can be made. See Section 28(6) of the 2011 Act. Indeed, the arrangements that the Council has adopted set out the procedure for doing that. We have now reached the final part of the second of those two stages. Before it makes any decision in respect of the allegation, a local authority must seek the views of the independent person, see Section 28(7)(a) of the 2011 Act. That includes consideration of any action to take in relation to such an allegation, and Mr Tompkinson has now provided his views. Those views are to be sought and taken into account, but they do not bind the subcommittee. The subcommittee is required to take its own independent view as to what the appropriate sanctions are, if any. Secondly, the subcommittee is not acting as a court of law. It is acting as a subcommittee of this Council, discharging the Council's functions under the Localism Act 2011. As with any decision of the Council or its committees or subcommittees, the decision that the subcommittee reaches must comply with general public law obligations. And these include: A, the decision must be lawful. The subcommittee must not exceed its powers under the Localism Act 2011, or the Council's constitution, or the arrangements that the Council has adopted to deal with standards matters. B, the subcommittee must have regard to all relevant considerations. C, the converse of that is that the subcommittee must not have regard to any irrelevant considerations. So, for example, party political advantage would be a matter that it should not have regard to. D, the subcommittee must act for a proper purpose. In this context, that proper purpose is identified primarily by Section 27(1) of the 2011 Act, namely promoting and maintaining high standards of conduct among members and co-opted members. The decision must be a rational one. It must be a decision that is not what is known in legal jargon as the decision that is not what is known in legal jargon as wednesday unreasonable. That means that the decision must not be so irrational that no reasonable decision maker could have reached it. And finally, F, the decision must be reached in a procedurally fair manner without actual or apparent bias. My third general point is that the subcommittee's members must also comply with their own obligations under the Code of Conduct, and in particular must have regard to the need to decide matters objectively and impartially, and to exercise their own judgment. Fourth point, the subcommittee must be conscious of the fact that Councillor Hussain has not been present or represented at the hearing and has not had the opportunity to make representations or respond to those made on behalf of the investigating officer. However, of course, the subcommittee has also already decided today that Councillor Hussain was afforded a proper opportunity to prepare for this sanctions hearing had he chosen to do so. The fifth general point is that the subcommittee must decide the case based only on the evidence and submissions that it has received, and that is equally true in relation to deciding on sanction. So that's the evidence that the subcommittee has already received and considered at the hearing on the 8th of January. The material included in the large series of hearing bundles, the further documentation handed up at that hearing, and the evidence that was heard orally from witnesses at that hearing. The small number of further documents that have been included in the agenda and supporting documents for this sanctions hearing. The subcommittee should not take account of anything that it has read or in the press or seen on television or heard on the radio. It should not take account of any communications or blogs or any other extraneous communications from third parties. The subcommittee members can, in my view, in appropriate circumstances, take account of their general knowledge as councillors of how councillors operate and so on. But they should not take account of anything that would constitute knowledge of the particular facts of this case. My final general point, number 6, is that the subcommittee will need in its reasons to explain why it considers that imposing a sanction is appropriate, if it does, and if it does consider it appropriate to impose any sanctions, why it has imposed the ones that it has. It does not need to deal with absolutely every point made to it in submissions, but should address the main ones. The parties, that is the investigating officer and the subject member, Councillor Hussain, are entitled to know why the subcommittee has decided as it has. I now move on to more specific advice in relation to sanction. The Localism Act 2011 doesn't say very much about sanction, but at section 2811 it says this: if a relevant authority finds that a member or co-opted member of the authority has failed to comply with its code of conduct, whether or not the finding is made following an investigation under arrangements put in place under subsection 6, it may have regard to the failure in deciding A, whether to take action in relation to the member or co-opted member, and B, what action to take. So the first question that the subcommittee will need to address is whether to take any action at all. That is clear from the statutory provisions governing this regime. There may be cases where a local authority considers that merely the finding of a failure to comply with the code and the publicising of that finding is a sufficient sanction. If the subcommittee concludes that that is not appropriate in this case, then the next step would be for the subcommittee to go on to consider what further action might be taken. The relevant section of the Council's arrangements is section 9. That sets out a non-exhaustive list of potential sanctions that the Council, acting through the subcommittee, could take. Namely, it may 1. recommend the member's group leader, or in the case of an ungrouped member, recommend to Council or to committees that he or she be removed from any or all committees or subcommittees of the Council. 2. recommend to the leader of the Council that the member be removed from Cabinet or removed from particular portfolio responsibilities. Or 3. instruct the monitoring officer to arrange training for the member. 4. recommend to Council to remove the member from all outside appointments to which he or she has been appointed or nominated by the authority. 5. withdraw facilities provided to the member by the Council, such as a computer, website, or email or internet access. And 6. exclude the member from the Council's offices or other premises, with the exception of meeting rooms as necessary for attending Council, committee or subcommittee meetings. The key points to note are that 1. There is no power for the subcommittee or indeed the Council either to suspend Councillor Hussain or to exclude him from office or to withdraw any members or special responsibility allowance. Secondly, in considering what sanction to impose, the subcommittee will need to, quote, take such steps as appropriate, reasonable and proportionate to the particular conduct that amounted to the breach of the Code of Conduct. So the subcommittee will need to bear in mind its findings as to what Councillor Hussain did or did not do, and will need to have regard to which particular provisions of the Code it has found that he failed to comply with. In this case, the 3 materially identical provisions of each version of the Code are paragraphs 3.2d, 5 and 6a of the 2007 Code, and paragraphs 12.2d, 12.3 and 12.6 of the 2012 Code. And those are set out in detail in the decision notice. Thirdly, the subcommittee will need to have regard to the underlying purpose of the regime in deciding appropriate sanctions, namely to promote and maintain high standards among members and cooperative members. Fourthly, the subcommittee will then need to consider which of the list of potential sanctions are relevant in this case. Some would appear simply not to be relevant, while others may well be. And fifthly, balancing that up, taking account both of factors that the subcommittee considers are potentially aggravating and also factors that are potentially mitigating, the subcommittee will need to decide what is appropriate and proportionate in this case. Two particular points in relation to what the subcommittee may wish to take account of are these. Firstly, the passage of time. It is now over between 6.5 and 5.5 years since the breach that took place, that is the subject of allegation 1. And between nearly 7.5 and 6.5 years in relation to allegation 1, and between 6.5 and 5 years, 6.5 and 4 years in the case of the breaches that are subject to allegation 2. So a number of years have passed since the events that were subject to the allegations, and that may well be a factor that the subcommittee considers to be relevant. The other factor I want to highlight is insight, or lack of it, on the part of Councillor Hussain. It is often the case that bodies that are imposing sanctions for conduct breaches, not just in this context, but in the professional context, will need to consider whether the defendant has shown insight into the behaviour that has led to the misconduct. That can be relevant as a factor both going to potential mitigation, but also indeed an aggravating factor if there is an absence of insight. The subcommittee will also, my final point, need to determine the period for which the decision will appear on its website, which should be at least as long as the period for any requirement imposed by the subcommittee to be complied with. That's my advice in relation to sanction. I'm very happy to take any questions from the subcommittee on it.
Is there any questions at all from the subcommittee? No? No?
In that case, perhaps if Ms Price has any observations.
No, thank you. I agree with the advice.
The subcommittee will now take an adjournment to decide the actions. Thank you. Well, I'm sorry about the long delay, but we had to get it right. The subcommittee has deliberated and reached a decision on sanctions, and I will now hand you over to James Cornwell, the legal advisor, for a summary statement. With you, please, James.
This is a summary of the reasons of the subcommittee in relation to sanction. It's the decision of the 4 members of the subcommittee with advice and assistance from myself and from the independent person. 1. The subcommittee has considered what, if any, actions to take following its decision that Councillor Hussain failed to comply with paragraphs 3.2d, 5 and 6a of the 2007 Code and paragraphs 12.2d, 12.3, 12 and 12.6 of the 2012 Code. 2. The subcommittee had particular regard to its findings made in relation to Councillor Hussain's failure to comply with the codes. 3. The subcommittee considered that Councillor Hussain's breaches of the codes were at the most serious end of the spectrum. His conduct evidenced a number of aggravating factors. A. Councillor Hussain was a senior member of the Council, a Cabinet member and deputy leader. B. His conduct in relation to the toilet sale involved a sustained course of misconduct over a period of 10 months. Taking the allegations together, his misconduct spanned a period of from 2011 to 2014, a period of 3 years. C. The conduct subject to both allegations evidenced a similar pattern of misconduct involving abuse of position, suborning officers to undermine their impartiality, and disregard for the good stewardship of public resources for the benefit of a close associate or family members. C. Councillor Hussain was plainly aware of the code and had been trained in it. Councillor Hussain showed serious disregard for the code. D. There has been no insight into or understanding of his conduct or its effects. Indeed, Councillor Hussain, falsely, as the subcommittee has found, denied involvement. E. Councillor Hussain failed to cooperate with the standards process. He sought unsuccessfully to halt the process by a judicial review and sought to delay the process repeatedly, which cannot wholly be explained or justified by his health. F. His actions have caused financial loss to the council. G. The way he has approached the standards process has caused further damage to the council's reputation and the reputation of the standards process. 4. The subcommittee has sought to identify mitigating factors. It has, however, struggled to do so. The subcommittee recognised that the conduct took place at least 4 years ago. The subcommittee noted that Councillor Hussain had cooperated with the RAG investigation and initially cooperated with the standards investigation. However, his cooperation declined as matters progressed, and the subcommittee considered cooperation was no more than could properly be expected of a member. The subcommittee noted that it had not been established that Councillor Hussain personally gained from his actions, but regarded that as an absence of an aggravating factor rather than a mitigating factor. 5. The subcommittee considered that it was constrained by the current statutory regime governing governing standards as to the sanctions that it could impose that properly reflected the seriousness of Councillor Hussain's misconduct. The subcommittee also recognised that it could not take steps that would prevent Councillor Hussain from discharging his duties as a ward councillor. 6. The subcommittee considered that in deciding what action to take, it had, so far as it could, to adopt steps that properly reflected the seriousness of Councillor Hussain's abuse of his role and to protect the council from the conduct he has been found to have engaged in and to prevent its reoccurrence. 7. The subcommittee therefore decided: A. This was a case where further action was appropriate and proportionate. B. The subcommittee expresses its grave censure of Councillor Hussain's actions. C. The decision notice on the breach decision and the decision notice on sanction be placed on Councillor Hussain's council website profile for the length of his next term of office on the council, if and whenever that might be. D. The monitoring officer arranged training for Councillor Hussain to cover his role as a member, his role as a portfolio holder, property transactions, best consideration, principles of the code, understanding of what ways he breached the code and what he could have done differently. Such training to be completed to the satisfaction of the monitoring officer within 6 months. E. A system be put in place to regulate Councillor Hussain's contact with officers. All communications with officers are to be through the director of the relevant service, in writing or by email, or otherwise only with the specific approval of the relevant director, unless in an emergency, in which case Councillor Hussain will notify the relevant director of the contact as soon as practicable afterwards. F. The subcommittee recommends that Councillor Hussain not be appointed to any committee, to cabinet, or to any outside appointment on behalf of the council until the end of a period of 4 years from the beginning of his next term of office, if elected. that is a summary of the subcommittee's decision on sanction.
And that, ladies and gentlemen, concludes